I'm Matthew from Frontline Law. In this video, I'm going to talk about fixed-term employment contracts. If you're an employee, you could be on several different types of contracts. You could be on a permanent contract, you could be on a fixed-term contract, or you could be on a casual contract. Most people are on a permanent contract, meaning that you're employed to do a job and there's no end date to that employment. It ends when either you're dismissed by your employee, maybe because of redundancy or potentially performance or conduct issues, or you resign. It's open-ended employment. Casual employment is when there's no expectation of ongoing work. You are employed for the hours that you are given, but there's no expectation that you would be given future hours. The final topic, and that's what we'll talk about today, is fixed-term employment. So fixed-term employment it's in the name. It's when you're engaged as an employee and that employment continues until it ends either by a fixed date or maybe when a certain event happens, like maybe external funding stops being provided or a project is completed, maybe when someone returns from parental leave. Fixed-term agreements are governed by the Employment Relations Act, and it's really important that employers comply with the requirements under that act, because if they don't, then a fixed-term arrangement would be treated as a permanent arrangement. And if an employee has come to the end of the purported fixed term and is released or dismissed or their employment ends, but in fact it was an arrangement of one of permanent employment, then they may have been unjustifiably dismissed, and that's liability for the employer. So Section 66 of the Employment Relations Act says that a fixed-term employment agreement has to contain genuine reasons for that fixed term based on reasonable grounds for specifying that an employee's employment would end on a specified end date or by a specified event. Now, typically, fixed-term employment is one-off employment. You're employed to do something for maybe 3 or 6 months, maybe even a year, and at the end of that time, your employment ends. But sometimes employers can put employees on multiple fixed-term agreements. So when one fixed-term agreement ends, it's reviewed, maybe the end date is amended, and their employment continues. And this can happen 1, 2, 3 times. In some cases, we've seen it happen over a dozen times. And this is permitted, but it's important to remember that you still need to have that genuine reason for a fixed term based on reasonable grounds. And the more times that a fixed term agreement is renewed, the harder it can be for an employer to satisfy the court or the authority that the fixed term is for genuine reasons based on reasonable grounds. The Employment Court has said that the greater the number of consecutive fixed-term agreements, the more carefully the court or authority will scrutinise the validity of the fixed-term employment arrangement. There's a few cases that I want to talk about. It's helpful to go through relevant cases because it helps us understand how the courts or the Employment Relations Authority will treat similar situations. So the first one is a case called Canterbury Westland Free Kindergarten Association and New Zealand Educational Institute. So this case involves a school bus driver who was on a series of fixed-term agreements for more than 18 years. Now, the employer argued that its funding arrangement for the school bus services was a genuine reason based on genuine grounds for having a fixed-term agreement. In the Employment Court, the court accepted that at some point a pattern of renewing fixed-term agreements could break. In this case, the court said that the possibility for external funding not being renewed wasn't enough for meeting the threshold for having a genuine reason for a fixed-term employment. And the court said that every business faces financial uncertainty to some degree, and in this case, funding had been renewed for more than 18 years, and so it wasn't justified, it wasn't a genuine reason for the employer in that case to continue to have fixed-term arrangements. In another case called the Lyell and Board of Trustees of Clow Morgan School, a teacher's aide challenged her fixed-term agreement, saying that it was in fact a permanent arrangement. But in that case, because the teacher's aide was being paid with external funding, and because the need to have her work depended on having students in the school that required a teacher's aide, the authority decided that there was a genuine reason for the employer in that case to have a fixed-term employment arrangement for some of her hours. In another case called New Zealand Educational Institute and Board of Trustees of Red Beach School, the Employment Relations Authority said that because the role was stable, because there was a waiting list of students trying to enrol in the school, and any fluctuations could be managed under provisions in the employment agreement to vary the employee's hours, it was unreasonable to have a fixed-term agreement for that teacher's aide. Finally, there's a case of Crossley and Quick Kiwi Cars. And in this case, an employee was on a 4-month fixed-term employment arrangement while the employer merged two businesses. Now, the employer said that they expected to find role duplications once they merged the business, and there would be a need for restructuring following the merger, and this was the reason for the fixed term. The employee argued that this wasn't a genuine reason based on reasonable grounds. Now, the authority agreed with the employee and said that the employer should have terminated the employee's employment on terms of redundancy because there had been no consultation, the dismissal was unjustified. And the authority said that the employer couldn't rely on the fixed term expiry to end the employment. So those are just a small set of examples of how the authority and the court have treated fixed term agreements in the past. And I'm going to return to the law, and that is a fixed term agreement must be for genuine reasons based on reasonable grounds. And if an employer can't meet those two requirements, then a fixed term arrangement is in fact a permanent arrangement. If an employee comes to the end of the fixed term arrangement and it's not renewed, then the court may well say that they've been unjustifiably dismissed. So if you're an employer, it's really important to seek advice and make sure that you have genuine reasons on reasonable grounds and that those things are set out clearly in the employment agreement. Talk to a lawyer, talk to us, have a free initial consultation to make sure that you avoid any risk that might come along with that. If you're an employee and you've come to the end of your fixed term agreement or arrangement and you think in fact it might be one of permanent employment, talk to us about your options. We'll be upfront with you. If we think that it's a fixed term agreement, we'll tell you. But if we think that there's an argument that in fact it's a permanent agreement and you've been unjustifiably dismissed, we'll talk to you about your options. Thanks for listening.